Anthony.
My name is Julie Bravko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. So first, I want to remind you all to join us next week. At that time, we have Danielle Reinzig, who's going to be presenting Implementing Equity, Diversity, Inclusion, and Belonging Curriculum in Forensic Training Programs, Educating the New Culturally Humble Generation of Forensic Psychologists. Next, for our talk today, please ask your questions in the Q&A anytime you feel comfortable. Just know we're probably not going to get to them until the end. As always, we do try to get through as many of your questions as possible, so please forgive me ahead of time if we can't get to yours. In terms of the slides and the recording, we will be sending the slides out. We will be sending the recording out. Please give us about a week before you start emailing and asking for them. But if you don't receive them within, after a week, please let us know and we'll make sure we get those over to you. So now it's time for what we've all been waiting for. I'd like to introduce to you our speaker for today, Professor Joshua Kastenberg. Professor Kastenberg is an associate professor at the University of New Mexico School of Law. Prior to joining the faculty in 2016, he served in the United States Air Force for 23 years in a variety of capacities, including intelligence, cyber national security, prosecution and defense counsel, and as a military judge. He has authored several books and law review articles in the field of criminal law and ethics. And most recently, he published The Campaign to Impeach Justice William O. Douglas, Nixon, Vietnam, and the Conservative Attack on Judicial Independence, a study on how the Nixon administration tried to impeach a sitting justice while at the same time expanding the Vietnam conflict into Cambodia. In addition to his academic work, Professor Kastenberg has served as a judicial ethics advisor to the Romanian and Kazakhstan judicial branch, as well as for the state of New Mexico. Professor Kastenberg, we're so grateful to you for sharing your time and expertise with us. On behalf of the University of New Mexico, I'd like to welcome and thank you for presenting today. And I'm now going to turn it over to you.
Well, thank you very much for that kind introduction, and thank you for having me here. It's an honor to be talking to this august group and also about this topic. What I hope to cover in this topic, and this includes questions you may ask, is what is the role of the judge as a gatekeeper, and what happens when medical ethics collide with prosecutorial zeal? And in that regard, prosecutorial zeal should not be equated with unethical conduct on the part of a prosecutor, but rather there's certainly ethical zeal, and then of course there's unethical zeal, and we'll get into the rules of legal ethics. Now, I am going to use the case study approach, but I'm reminded of a few things in my time as being a judge, and how many records I saw in camera, which means neither the prosecutor nor the defense counsel got to review those records. Those records came in two forms. One I won't cover, other than to say we had a number of trials that were at the top secret or secret level, and of course some government agency hands those records over to the judge and says, Your Honor, these are top secrets records. Please don't divulge them unless the Sixth Amendment requires it, and give us an opportunity to object. The other records, ones that I will touch upon today, involve medical and psychiatric and psychological records of victims or of defendants. And all of those records are protected both by privilege and by formal federal statute or analogous state statutes. And what I'm reminded of as I talk about this is that both sides, the prosecutor and the defense counsel, really want to get at those records. The prosecutor wants to get at those records to make sure when they're covering a direct examination of a crime victim that they're not being led astray by either the crime victim or the police or the perceptions of witnesses to include the crime victim. Of course, the defense counsel often wants to get to that those records because they want to fashion the most cutting and poignant cross-examination that they can. Now, I'm going to be focusing mainly on the prosecution, and I'll say this up front why I'm going to do that today, and the judge, and why not so much on the defense counsel is this. I do tell my students I neither favor prosecutors nor defense counsel. Both have a critical role in our society, and for that matter, a constitutional role in our society. But their duties are different. The duty of a prosecutor is not to secure a conviction, but it's to represent the people of an entity, whether that entity is the state of New Mexico or the people of the United States, or for that matter, as some of my peers have gone on to international criminal tribunals, the people of the world. And that's a fundamentally different role that comes with a public trust than a defense counsel whose fidelity and attentions must be placed on her or his client first and foremost. And so there's an expectation in the rules of ethics that there's two different sovereign sets of ethics. Some of them are identical, but because of the differing roles, defense counsel may appear to get more leeway, although I'd argue that's not necessarily the case. Now, I mentioned the case study role. So I'd like us to imagine this as we get into the topic. So I want you to imagine for a second that you're a psychiatrist and you receive a call from the local district attorney. And after the police arrest a person, you get this call and the person has taken the lives of 11 people. Now, this is a real case. The lives of the 11 people are random. So this is not a family violence case. This is, and it's not in terms of an armed robbery. These are 11 premeditated murders. So one of the most serious offenses on the law books. The district attorney tells you that the suspect is openly confessing to the police even before the police read the suspect his or her rights per Miranda versus Arizona. Believe it or not, sometimes that happens. The police they have to inform the person of the nature of the crime they're suspected of before they question them. And in between the nature of the crime and the questioning comes the Miranda rights, which is the right to an attorney and the right to say nothing at all. But once in a while, and this really happened in this case, a suspect will just start confessing and say, I want to get something off my chest. And that's when a prosecutor or the police should have their antenna up at the highest level, because often that's when a false confession will come, or a confession that's so convoluted the prosecutor won't really be able to do anything about it because it's just simply not rooted in reality. So the DA calls you and tells you that the suspect is confessing, but also tells you that the confessions may be accurate, but the suspect is really strange. When the suspect was arrested, they were wearing an odd costume. In this case, the costume sort of approximated a Fred Flintstone costume. They were weird in appearance in the sense that they were disheveled. I shouldn't say weird, but what I mean to the DA's common language, that's what the language they use. Odd in appearance, disheveled, not particularly hygienic, and the effect, meaning the suspect wasn't looking at the police when the suspect was confessing. The suspect was looking up at the clouds and the sky and the like. And so they ask you to come in and take a look at this suspect for a potential evaluation, and you're on standby. Even if you don't work for the state, you're on standby and you agree to do so. And later, when you're asked about it, you'll say that you had an ethical duty to do this because there was a possibility that a strong possibility that the individual would not be competent to even give a full confession or be placed in the county jail with other inmates or other persons awaiting trial, and they could be a harm to themselves. So after conducting this evaluation, you determine that the suspect is fully cognizant of his or her surroundings and is able to appreciate the nature of the interrogation. The suspect gives another confession. So this is what happens in this case studies. 2 years later, the court, meaning the judge, someone who sat in the same bench that I sat on, albeit in a different sovereign, in this case it's in the state of California, appoints you as the psychiatrist to determine whether the defendant is capable of standing trial. The district attorney advises you that there's absolutely no conflict of interest after you ask the DA, well, look, you called me, your office called me 2 years ago and I gave advice, albeit on a different nature, but it's the same individual. They were a suspect then, now they're a defendant, and the DA responds to you, there's no conflict of interest whatsoever. The defense counsel knows about this, but doesn't seek to have you removed from the court appointment determination whether or not the defendant is competent to stand trial. Instead, the defense counsel calls a psychiatrist to impeach your ethics under the APA. This is a big wow. And when I read about this recent case from the California Supreme Court, I thought, this is interesting. I hadn't seen this one before. But here's an important point. Competency hearings in most states, not all, but most states, in New Mexico and California are two of them, are non-adversarial. And what I mean by that is my jurisdiction was non-adversarial as well. If I or a California judge or a New Mexico judge appoints a psychiatrist to determine whether someone is competent to stand trial or not, we're stuck with the answer as the judge. I may not like the answer. I can ask the individual psychiatrist further questions, but if the psychiatrist determines that the defendant cannot understand the proceedings and cannot assist in their own defense in the proceedings, we're stuck with that. And that's actual case law in New Mexico where I didn't post the case, but a judge made a ruling that the individual defendant, based on the psychiatrist's evaluation, was unfit to stand trial. A new judge was elected, came in and said, I don't like the old ruling. I'm going to vitiate it and call in a psychiatrist of my choice. And of course, there was a different result. But the New Mexico Supreme Court determined once the competency determination was made, and if it was made that the defendant would not at any time in the future be competent to stand trial or assist in their own defense, the judicial branch and the prosecutors were stuck with the answer. So they're non-adversarial, and this is a part of the criminal law where a psychiatrist or a psychologist has tremendous sway or absolute sway over the court. Now, there's a lot of things that can go wrong, and this was one of them. So the issues that arise in this case study is, number one, should the district attorney have informed the court that there might have been a conflict and then move the court, meaning motion the court, to appoint someone else? And by the way, there is a conflict here. The psychiatrist who asked the question was absolutely right. They were thinking in terms of APA conflict, but there's also a legal conflict of interest too. The second issue is, should the defense have been permitted to have called their witness for the purpose stated, impeaching your ethics? And that's an interesting one, because I can tell you, and I'll elaborate on this a little bit further, but judges do not like ethics battles in their courtroom. And then third, what should the court have done in this instance? So the first answer is, it's clear that the district attorney wanted a particular result, and you would give that result to him or her. But the district attorney has an obligation to the court and should have motioned the court to remove the appearance of bias. So the DA should have done this on her or his own. But if they didn't, you would be perfectly well within your rights as a professional, well within your own ethics, to bring up this issue to the court as well, even if the DA didn't want to do that. The second part of this is, should the defense have been permitted to have called their witness for the purpose stated, and that is impeach your ethics? And the answer is no. A psychiatrist is a medical expert. Though you're immersed in medical ethics, the court is not a place to conduct medical professional evaluations. The courts need to give deference to the APA boards in that light. But the psychiatrist should have been permitted to testify as to the defendant's lack of competency to stand trial. And what I mean by that is, the defense, had they called their psychiatrist for the normal reason, which is simply to disagree with your evaluation, then that psychiatrist would have been allowed to testify. And then finally, what should the court have done in this instance? And that is, thank you for your prior work, and appointed someone else. this is what I call the perfect storm. This California Supreme Court decision just came out this past year, and I apologize for the graphics, but when I thought about perfect storm, this picture came to mind. Let's get into then what attorney ethics are in the prosecutor realm and how attorneys are governed and how they're disciplined. Being an attorney is a profession. It's not a job. When I've taught ethics and when my peers teach ethics, that's something we talk about a great deal. And what is a profession? A profession isn't only because somebody has a the highest degree in their field, be it a PhD, a JD, or the equivalent in other fields. It's that it's governed by, it's a self-governing entity. And so when engineers have oversight boards, they become a profession. That's a legal terminology. But the other thing is, attorneys are officers of the court within their own profession. So we graduate from law school, we take a state bar, and then we're admitted to practice by the highest state court in one of the 50 states, or Puerto Rico, Guam, Saipan, and the like. And then we're commensurately admitted to a federal court as a result of being admitted to the state court. Once we become officers of the court, we're bound by the rules of ethics. And it's the courts that either disbar or discipline, or they clear us from allegation of wrongdoing. It's not an independent commission set up by the legislative branch. It's not the Bar Association that does that. It's the courts. That's why judges have a heightened sense, or they're supposed to have a heightened sense about ethics rules when they look at this issue. There's a lot of fuzzy language in our ethics rules. Only persons of integrity or good character should be permitted to practice law, to which many of us have said, if that were true, how come there's so many disbarments or other antics that you see? Nonetheless, the New Mexico Supreme Court, in this case, our 5 justices, are the gatekeepers of the ethics rules, and they're the gatekeepers of law, and they determine who can and cannot practice within the state. Passing the bar exam is only one of the doors that open up to get someone to be an attorney. In other words, the state Supreme Court establishes and monitors other aspects of it. You have to be 18 years of age. I'm sure that'll get challenged at some point. Must be of good moral character, no adverse conduct in another jurisdiction, in compliance with all legal obligations, including child support and other judgments for support. We're lucky in New Mexico that we have the second lowest cost law school in the United States, but believe it or not, students who rack up huge student loan debts may be deprived of being admitted to the bar, because an excessive debt load means that someone is likely to take on too many clients and not really represent them well. Compliance with law school regulations, our dean has to sign that all of our graduates who are applying to the New Mexico or other state bars are worthy of the bar. Here's where attorneys get disciplined. Violations of the rules of professional conduct, or other court rules or statutes or other laws. Now, the other laws that I'm talking about are interesting, because we have in other law schools, you don't admit a student that you don't believe can't get admitted to the bar. But we've admitted students who've served time in prison for felonies because the crimes they've committed, while perhaps violent, have not been crimes of fraud. Recently, I think 2 years ago, Arizona State University, or the University of Arizona, made the national news when they admitted a student who'd served 20 years for murder and then had gotten out of prison early and become a model citizen. That type of person with that background can certainly pass for good moral character, but the person who commits identity theft off of senior citizens and is convicted and only serves 6 months is unlikely to get admitted. And that's just the nature of the way the bar works. When individuals who are already attorneys in New Mexico get accused of wrongdoing, and this includes prosecutors, there's a process. Complaints can be filed by just about anyone: opposing counsel, witnesses, other persons, even the judge. If the complaint appears frivolous, then the referee that the New Mexico Supreme Court appoints can dismiss on her or his own view. But if the complaint is facially meritorious, and this is where you come in, the prosecutor is trying to force me to do something that I feel I can't do, or shade my testimony in a certain way, that would make it a facially meritorious complaint. Then an investigation would occur. The referee gives it to the board. They make an initial determination, and then they give that determination to the Supreme Court, and the judges decide what to do. And here's what can happen. The court itself can dismiss a complaint. They can do an informal admonition, which means it's a private letter of censure telling an attorney, don't do it again, but the public won't know the nature of it. There can be a formal reprimand, probations ordered by the board or by the court, public censure, suspension, disbarment, and then, of course, if someone's been robbed of money, restitution. And every year in New Mexico, there'll be a dozen or more attorneys who go through this process, and they'll be suspended. It's rare that there's a lifetime disbarment, but they'll be suspended. More often than not, you get the informal admonitions and the formal reprimands. And this is true with defense counsel, prosecutors, civil attorneys, and the like. It's also true with judges, although judges go through a different disciplinary construct than this. There's a whole unique one for judges that stays out of the public eye for the most part until someone is removed from their job or formally reprimanded. That's going on in Wisconsin right now. It's happened in New Mexico. Though judges tend to resign or retire from office when they get into trouble. There was a judge in one of the outlying counties that had a third DUI, and rather than face the New Mexico Supreme Court, they simply resigned their office. So these are the things that can happen. And I'm not suggesting that you act with zeal to make them happen, but they are the governing mechanisms of the court. Now, here's the two biggest things that will cause someone to get disciplined by the court in New Mexico: the lack of candor towards the tribunal. And this includes trying to bully witnesses into shading or shaping their testimony in a manner most advantageous to their side, when that testimony is either untruthful or that testimony omits important facts. And I've seen this occur before, and usually the medical experts are very good at telling the court, well, I'd like to add something to my testimony. And at that point, either the prosecutor or the defense counsel regretted calling the expert to the stand. For example, I was sitting as a judge on a child abuse case. There was a spiral fracture. Normally, spiral fractures are a good sign that a child has been physically abused by some adult. But in this particular case, the expert was that the government's expert, who was a radiologist, was absolutely willing to testify that it was a unique spiral fracture that could have occurred on a merry-go-round where an arm got caught in it. And the prosecutor didn't want to bring that out, but the individual, a medical expert, brought that out on their own before cross-examination. Fairness to opposing counsel means putting opposing counsel on full notice of what you're going to testify to. As an expert, if you're called to the stand, or if you're a consultant who may be called to the stand and there's an opening, that meaning a requirement that you talk to opposing counsel, you have an obligation to tell opposing counsel what you're going to testify to. And no prosecutor, or for that matter, defense counsel, should ever tell you that your work is privileged and therefore you don't have to openly discuss with the other side, if they interview you, what you're going to testify to. Now, what's the role of the judge in all this? This is a difficult one because judges have different views. I mean, there's more than two views, but there are two prevailing views. And it's caused by a tension in the system. Some individuals view their job as a judge as a referee. And a referee means that you're making sure that both sides are being fair to each other. Other judges, and I tended to fall into this category, agree with that, but add the following. And the following is that in criminal trials, you are the guardian of the Bill of Rights. And so while you're making sure that procedurally both sides are playing by the rules and being fair, you do owe the defendant the protection of their basic constitutional rights, meaning you have the authority as a judge to sua sponte, and I try not to use too much Latin, but sua sponte, meaning on your own, without being motioned by a prosecutor or a defense counsel, to make rulings or to issue orders to the parties, or even ask a witness outside of the presence of a jury. Is that all you're called to testify to as an expert? Is there some other area that you believe is pertinent to your testimony? Now, you're not supposed to take the side of either the prosecutor or the defense counsel, but if you believe as a judge that an expert is available to further flesh out their testimony, you can certainly ask them that. And of course, judges have the authority to call someone in contempt. I did that twice in my career as a judge, and both times it was on counsel, not on witness. There was a prosecutor who drew an allusion to a defendant, and the defendant was being prosecuted for a sexual assault. But the defendant had an Arabic name, and the prosecutor drew an allusion in closing argument to the 9/11 hijackers. And that led me to shut the argument down and issue a contempt order on the prosecutor on my own, because there's no place for bigotry or calls for bigotry in a court of law. The cases that I mentioned about what a judge's job is are found in very old cases, Toomey versus Ohio and Berger versus United States. And let me throw in one other thing on this as we get into a couple of other case studies along the way. I know the medical world and the legal world are both concerned with personal information, with HIPAA, and with privileges. But when I put a name up there, it's a case name. And even if it's a recent case, it's a case name. It's published in the law books. The Sixth Amendment not only permits, but requires the publishing of certain data, and case names are one of them. It's a public's right to a trial. So there should be no concern about that. I had this quote in my office as a judge. I give this to trial judges when I teach at the National Judicial College or any other trial judges work. Justice Henry Grattan Nolan died many, many years ago. He was a justice on the Supreme Court of Canada. And he was asked by a new crop of Canadian trial judges in the year 1952, what do you really think your job is when you become a judge? And he said a trial judge has done his or her duty if after the introductory instructions, juror selections, opening statements, and up until deliberations, the jurors see not a prisoner in the dock, but instead they see a usual man doing his usual business in a usual place. And I think that if you look at a judge's job and making sure that a courtroom is fair and that a criminal trial comports with the Bill of Rights, and you take a look at this quote, and the Canadians do have a Bill of Rights very similar to ours, albeit much newer than ours, so it's actually more robust. It makes sense. And that's why I say that you can always go to the judge if you believe you are being pushed into positions that you shouldn't be pushed into while you're on the stand. And the judge ought to be able to clear the courtroom and flesh out exactly what the issue is. Now, I'm going to skip for a moment, or just skip through competency and due process. But here are the important points. An incompetent person cannot be prosecuted without violating that person's due process. Why? Because a person has a constitutional right to assist in his or her own defense, and if they can't do it, this right is meaningless. You can go back to the 19th century and find cases from the decisions of the Supreme Court. This is old law. Decisions such as whether to testify, however, are the defendant's to make, and the waiver of the right to testify must be knowing and conscious. And this is where you might get called in. And this happened in the Ted Kaczynski case with the defense counsel. suppose a psychiatrist or a psychologist finds someone competent to stand trial, but the person is delusional in spite of that. The decision for a defendant to testify is his or her alone, and the defense counsel cannot stop them from doing that. And the prosecutor will be salivating usually at the opportunity to. But what if you have a concern about that? You've determined for the court that the defendant is competent so they can assist in their own defense. But what if they're not immersed in reality? There's something in the DSM-5 that you can put your finger on that to say, but having them testify would be a major disaster. It would bring a manifest injustice on the court. That's the legal term. You have it within your authority to do that, and even if inform the court of that, even if the prosecutor doesn't want you to do that. And that's because you're as an expert, you're not a hired gun. Here are the New Mexico rules. Since the slides are available, I won't read the fine print. This is the case I earlier talked about, but I think it bears going through. And it shows you the authority that you have in the eyes of the New Mexico Supreme Court. The name Gutierrez is actually is not the defendant's name in this case. This has to do with some unique feature of how cases are named. Normally they have the defendant's name, but not in this case. So Davis was charged with kidnapping, hostage taking, attempted first-degree murder, 23 charges in all. He was diagnosed as having an IQ of 62. Judge Douglas Diggers ordered a second evaluation on the motion of the prosecution. Initially, the first evaluation found him Davis incompetent to stand trial. The second evaluation found him not competent to stand trial as well. Two different psychiatrists arrived at that. Based on the result, the judge found that Davis was not competent and ordered him into a treatment facility to try to obtain competency. A 90-day review found him not competent and unlikely to ever become competent, and found him to be likelihood of future dangerousness. The defense counsel then motioned Judge Diggers for a competency evaluation based on mental retardation. These are two different features of it. So now there are three different competency evaluations, but in New Mexico, like 42 of the other states, judges are elected. Judge Schultz ran on a tough on crime platform. She replaced Judge Diggers. And when she took the bench, she found on her own Davis competent and ordered him to stand trial. So the issue is, given the non-adversarial nature of a competency hearing, was the judge within her authority to reverse the prior ruling? And the answer is no. Under the state statute, and this is true in the federal trials as well, once a judge makes a ruling based on competency, the court is stuck with it. And that includes superseding judges. And when I say this is the power that you have, it's not that you're granted power if you're a psychiatrist or a psychologist appointed by the court to do what you want. Obviously, it's the power to apply your expertise in a manner that lawyers and courts are wholly incompetent to apply. Up until this point, it's been non-adversarial, but now, what happens when one side or the other or the prosecutor wants to get into your information? Of course, there are privileges. Jaffe versus Redmond is the first important privilege. It starts with a civil case, but it's now become part of the criminal law in spite of Justice Scalia's dissent in it. And what I'm getting at in that is if the prosecutor tells you, I want to get at your information, you've testified either in a non-adversarial proceeding or you've been called for the defense or by the court, and the answer to that is no. If you've evaluated the defendant, the prosecutor is not entitled to your data unless the court orders it. And in order for the court to order it, you have to be first given the right to oppose that. And to me, as a judge, and to my fellow judges, this is old hat. And yet over and over again, year after year, Psychiatrists, psychologists, and other medical professionals will come to the court and say, the district attorney is telling me I have to hand over my victim or my defendant competency evaluations, the data, that I used, whatever testing that I used. And the answer to that is no, it's privileged. And so go to the court, tell the prosecutor, file a motion to the court, but you shouldn't be bullied into handing that over. Now, of course, there's the Tarasov case. And if somebody you've evaluated is going to be released and you believe that that person is a danger to specific individuals or society generally, you do have a duty to divulge that information to the court. Okay, in that vein, criminal trials are adversarial, but they're not a blood sport. They're a truth-seeking function that the expert can help with. I bring up the agent orange litigation and the evolving standards of expertise for one fundamental reason. And this is, I've talked about guarding your ethics, and I've talked about your expertise and what it means, how important it is to the court. But most prosecutors, most defense counsel, for that matter, most judges have a very hard time keeping up with the science. And the reason for that is we're not scientists. Most of us came into the law with history degrees. I can tell you that I know a lot about John Calvin, Martin Luther, and the Protestant Reformation because that's what I focused on as an undergrad. My science, not so strong. And most of my peers are like that. If you think about when the first expert rule came about, it was in 1922, and Daubert versus Merrill Dow, which is more recent, but it just built upon that 1922 rule, is very basic. It simply says that if the individual who's going to testify has either the commensurate level of education or the commensurate experience to testify to what they're going to testify to, if it's scientific data and it would be helpful to the court, then it comes into evidence as an expert. But if you think about what the world was like in 1922 when this rule came out, and you think about the world today, we've come a long way. And we keep coming a longer and longer way. In fact, every year, data is exponentially growing. And here's the thing about Rule of Evidence 702, both on the federal side and in New Mexico, the expert rules, what's going to make you different, and this is what's going to get prosecutors to ask you to shade your testimony at times, is that unlike a normal witness, you as an expert, if you're called to testify, are allowed to give hypotheticals and opinions that are not yes or no answers. So for example, if I'm crossing the street, I mean, if I'm in a tort case or even a criminal case and someone runs a red light, and let's say the defendant said, I tried to brake, but my brakes failed. If I'm a lay witness, meaning the 99% of the witnesses the court see, just someone who witnessed an event or has knowledge of the event, I can't testify the percentage of chances that a brake would fail. I can't testify about the weight of the Ford F-150 pickup truck and how long it takes to stop going at 30 miles an hour. And I certainly am not entitled to testify to reaction times of human beings generally. But as an expert, you're allowed to do that. You're allowed to testify to the what ifs and the hypotheticals within reason. Now, I make this comment to my students every year. There's a limit to that. It's feasible that a Volkswagen Jetta can fly to the moon on its own. I suppose some physicist will come up with an equation that a Volkswagen Jetta can fly to the moon. I use that as an example. I don't know why I was stuck on Jettas years ago, and I use that as an example. But you wouldn't really be allowed to testify to that in a court of law because that, quote, strains credulity, unquote, meaning it's highly imaginative, it's theoretically possible, but only on the farthest fringes of physics. On the other hand, just about everything else is a possibility. And the problem with that isn't that you are able to do that. The problem with that is you may not want to testify to that because you believe it would violate the professions, the canons of ethics of your profession. And that's where your profession's ethics and your personal ethics may clash with the ethics of attorneys who will tell you you can't testify to that. My advice to you is your professional ethics trump the legal professional ethics on that point, because you can always tell the prosecutor, or for that matter, this is true with defense counsel, I won't do it, but if you want it to be done, find somebody else. But you can't be bullied into that. I mentioned the standard of Daubert, so I'll skip that. One other thing to understand, and sometimes experts get a little hung up on this, often it has to be peer reviewed. So I remember as a judge, the prosecutor called someone to the stand. It was an Arizona case, called a doctor to the stand who had recently given a paper at the University of London. The paper was very well received, and it's clear that the psychiatrist was on the cutting edge of what they wanted to testify to. It was very clear to me that they were a very well regarded psychiatrist in the academic community. In fact, they were the highlight of whatever conference it was. But what he wanted to testify to wasn't peer reviewed, and he volunteered that on his own. And I informed the prosecutor it can't be brought in. It can't be brought in because it's cutting edge. It's got to be the norm. And that's what State versus Jones came up with, the Ohio Supreme Court in 2019, which in my mind is absolutely right. Dr. Franklin's credentials were, quote, profoundly admirable, but his work in this criminal trial hadn't been fully vetted by the peer review process to be admissible. Now, where was the prosecutor in this? Assuring the witness that they would absolutely be able to testify to. One thing to understand about prosecutors in this light is prosecutors are expected to act with zeal, absolutely. But I mentioned earlier that they have other ethics standards that are unique to them, but to no other attorney. And that is, they have a duty to provide discovery, meaning all of the government's evidence, and in particular, known exculpatory evidence to a defendant. They have to believe that the evidence justifies the accusation. And in other words, not, I think so-and-so did it. There has to be some evidence that so-and-so did it. And has a duty of fairness to witnesses and court personnel. These are the ABA standards. They're not binding, but this is what gets attorneys disbarred. I say they're not binding because the states have adopted the ABA standards. Those are binding at the state level. And I mentioned Berger a little bit earlier, so I'll skip that. And I'd like to wrap up with a couple of case studies. So suppose you're a medical professional testifying in a proceeding to determine whether a defendant who has already been convicted of an offense and during a second unrelated trial was found incompetent. So this defendant, Stutler, he was convicted of some drug and larceny related offenses and was on a work release program. And he caused the prosecutor great embarrassment because he pled guilty in the first trial, and there was something that we often colloquially call a sweetheart pretrial agreement. The purpose of your testimony is for the court to determine whether or not to move the defendant into a trustee unit. Now, trustee units are designed for work release during the day. The district attorney opposes the transfer to the trustee unit because the second unrelated trial involved egregious charges of public displays, which is basically a nice way of saying indecent exposure. And Mr. Stutler liked to go to bowling alleys and restaurants and show his body to the world. So you have personal knowledge that a member of the medical staff at a prison hospital who reviewed Mr. Stutler had attended an alcohol treatment program after it was discovered that the staff member, a doctor, mixed reports and committed other administrative errors. Now, the doctor in the prison hospital is trying to, get their life back on track, and they did have they were put on probation for a while, but they're back at work, and that's not unusual. Two, you have personal knowledge that the staff has been investigated for breaching competency standards, but were cleared, although 2 confidential warnings were issued by the state board. And 3, the district attorney informs you that while such personal data is normally privileged to protect individuals, it's fine to divulge this information to the court because there's a protection of society issue the court must decide. So on the first one, it's improper to divulge this information because of HIPAA, but the court would be on notice that you have information of a general nature, and then the court will decide whether to hear it. The second one is confidential investigations in fields outside of the law, but by state agencies, will mostly remain privileged. The report should remain under seal and provided to the court. What I mean by that is when I was a judge, there was an arson case, and there are two types of investigations the federal government will conduct when a building is set on fire or catches fire. One is an investigation that's open to the public in the courts as to what caused the fire. The other, which is called a safety report, is investigating the firefighters to see if they acted appropriately in getting out the fire in the manner that they were supposed to do based on their training and expertise. That second report is a privilege report, and it's designed that way so the firefighters will speak openly and honestly to the inspector general doing that report. It's the same thing with the issue here in number 2. It's the privilege report, and it should remain privileged. You should not be, if you had access to the report, you shouldn't, and it should not be handed over to the district attorney. And finally, in terms of public safety, that's for the court to decide, but the district attorney is not entitled to the information until the court would provide it to the DA. I'm going to skip the Arizona cases up. Well, I'll cover that and then we'll wrap up. So in Ray Peasley, the court's prefatory statement sort of says it all. Government lawyers' role as a shepherd of justice. We must not forget the authority of the government lawyer does not arise from any right of the government, but from a power entrusted to the government. What happened here is you have a murder case, and the DA intentionally presented false testimony because he had substantial experience as a prosecutor. The Arizona Supreme Court was not inclined to treat his conduct with leniency. What he did was he encouraged a police expert who was a psychologist to testify falsely. After the psychologist testified, they had doubts about whether they should have done what they did. This is about shading testimony. They went to the court, and the district attorney of Pima County was disbarred and actually ended up in jail for other reasons. The same Pima County office had another attorney engage in disrespect and prejudice against mental health experts that led to harassment and insults during cross-examination. The defense counsel had called a psychiatrist, and the assistant district attorney belittled them on the stand. The judge held the assistant district attorney in contempt, and the Arizona Supreme Court determined that harassing expert witnesses is beyond the pale, and it undermines the defendant's right to a fair trial. It's a form of unethical behavior, and the assistant district attorney was suspended for 6 months plus a day. Why does 6 months plus a day matter? Well, in Arizona and New Mexico and a handful of other states, that gets a case published. And so that's why there's an N. Ray Zawada and an N. Ray Peasley. Otherwise, the public wouldn't know about it. And then finally, Schaub is a bit of a dated case, but I still like to present it. A prosecutor presented a defense mental health expert with falsified data. So now the shoe's on the other foot. Pretend for a moment you've been hired by the defense counsel, but the prosecutor has given you a bunch of falsified data to make you redo the MMPI test that you're going to do so that it becomes shaded in a manner most favorable to the prosecution, meaning you won't testify. This expert caught on to the prosecutor's conduct and informed the court, and the Florida Supreme Court suspended Schaub from practice. So I'd like to end it with there because we're at the 50-minute marker, and there was just 2 more case studies that would be somewhat redundant. But the reason I bring those case studies up is to encourage you to think about what your ethics are, what your profession means, and the fact that none of that has to be curbed by prosecutorial zeal. And when all else fails, if you're butting heads with the prosecutor, you can always go to the court. I don't encourage you to go to court in all instances, but it's when all else fails. In other words, the dictates of your professionalism, both the profession itself and the ethics of your profession trump prosecutorial zeal. And frankly, if there's a conflict between legal ethics and medical ethics prevail over legal ethics, as long as that does not work to the detriment of a defendant. And that's the state of the law. And with that, I'd like to just say one more thing before we wrap up. I mentioned that defense counsel are different. Defense ethics, I know prosecutors will say they're loosey-goosey, but they're not. Defense ethics are designed because a defense counsel has one client, and that's the defendant, and their fidelity must be towards the defendant. They're not supposed to do anything unethical, and there's plenty of case law on that, but defense ethics are different. In other words, if you've been retained as a defense consultant and you tell the defense counsel your client has no rehabilitative capability whatsoever, the defense counsel's under no obligation, nor should they share that with the prosecutor. On the other hand, if you're retained by the prosecutor and the prosecutor is told by you, the defendant in this case has excellent rehabilitation potential, and the prosecutor starts presenting evidence to the contrary, you need to encourage the prosecutor to share your findings with the court. And there's case law on that point as well. And with that, I will end that and ask if there are any questions.
Thank you so much. We actually have a number of questions.
Excellent.
So first, what is your view of the role of a medical expert? Are they an independent entity advocating for their position? Are they an officer of the court? Are they both or other?
Well, I hate to give it depends, because that's philosophical, but if I'm the judge or any other judge appoints a medical expert, they for a competency hearing, they become both an expert and an officer of the court, because that's a non-adversarial hearing. So they fall under my direct protection. In other words, and I would treat them as simply an adjunct to my duty as a judge. Now, if they're a prosecution expert or they're a defense expert, they are a professional, but they're not an officer of the court at that point. So that's the depends, the cut line there.
And what is your view of the role of a medical expert, an independent entity, advocating for their position?
So the role of, just so I understand this, beyond being an advisor as an expert to the court, advocating for their position, meaning if their position is directly related to the court, then that's fine. They are an advocate. So suppose they make a finding on, I would say, for example, false confession experts. Obviously, if someone's being called to testify as to false confessions occurring with some degree of regularity, and that these are the sort of the environmental conditions that might make a confession false, they're advocating for the science, and the science is somewhat existing in tension within the community of mental health experts as well as within the law. But if you're testifying to false confession theory being viable, or a certain part of false confession theory being viable, that's a natural advocacy, and that's absolutely fine. On the other hand, it does remind me that I once saw kind of an argument between a forensic psychologist and a clinical psychologist based on their training, who would be more in the right. And I shut the argument down and I said, that's a debate that's not relevant to the court. That's an academic debate. And that has no place in my court, that kind of advocacy. But advocacy to a type of theory that's relevant to the trial, sure. Yeah.
So this next individual says they work at a state hospital that does forensic evaluations for the entire state. So they're an unbiased party. And it's often the case that the same evaluator evaluates a defendant for competency to waive Miranda, competency to stand trial, and criminal responsibility. Do you see an ethical concern in this particular scenario, like you indicated in one of your examples, and what's the difference?
So competency to waive Miranda, competency to stand trial. Well, while those are different things, if the same party is calling the individual, there isn't a conflict. Where the conflict begins is if the medical expert or mental health expert consults and guides the defense and then is being called by the court later, then you have a conflict of interest.
This next individual says they work in a state with a centralized forensic system where the prosecutor reportedly has access to all of their records without permission from the defendant. Do you have any thoughts on this?
Well, records generally are protected by both privilege and HIPAA. However, there are events at, or rather legal proceedings that if the defendant chooses to pursue, it requires the lifting of those protections. So for example, you have a defendant who has already been incarcerated and they're trying to get parole, and their argument is they're no longer a danger to society or the like, then the prosecutor would be entitled to a portion of those records as those records are relevant to the hearing before the court, because there's no constitutional right to parole. That's a choice that an individual would make. On the other hand, there should be no blanket access by a prosecutor's office to medical or mental health records, just because. I mean, that would have to be driven by a choice of an administrative mechanism, administrative avenue that the defendant would be pursuing.
This next individual is asking about false confessions by defendants, and they're wondering why there's such untruthfulness or why these confessions are false, and what kind of mental disorders these individuals generally suffer from. And they're saying that you alluded to sway, and would psychiatrists over psychologists usually have more influence here?
It depends. The last part is it depends, because I once wrote a law review article on false confessions. And since I wrote that law review article, which was in 1997, the data and science on false confessions has ballooned in its growth. So, if someone, where you find false confessions occurring the most are people who have significant neurological impairments, low IQ, dementia, or environmental impairments as well. I mean, the police should never be interrogating someone who's mixed a cocaine, alcohol, and psilocybin mushroom cocktail, and yet that happens. The suggestibility level on that is rather high. But here's the interesting thing about false confessions. The public loves confessions. The framers of our Constitution, beginning with John Adams, didn't like confessions at all. They have to be corroborated because they recognize the influence of police or law enforcement on normal citizens and the gullibility. But here's the interesting thing about confessions. It's a quick story, I'll try to say. For much of our nation's history, up until the late 1930s, was something known as the Wickersham Commission. The police used the telephone and the physical, what we used to call the Chicago technique of interrogation. So someone would be beaten with a telephone book and they'd confess to anything. We know that interrogations under stress with things like waterboarding often don't yield anything. At Guantanamo, that's truthful. They yield what they believe the person committing the acts wants to know. But in the 1930s, a professor of sociology who worked for the Chicago Police Department named Frank Reed, and a law professor at Northwestern University named Frederick Inbau, and some psychiatrists around the country began studying how the human mind works in police interrogations, and they created something known as the Reed and Inbau technique. And the Reed and Inbau technique was supposed to take physical violence, but the technique itself is horribly coercive. It's overtalk the individual, crowd their physical space, find empathy with them, et cetera, et cetera. So when it's done well, even after Miranda, it does yield confessions, and most confessions are truthful, but it also puts certain people, based on whatever makeup they've had, what they had for breakfast or whatever, and just simply confessing to things they didn't do as well. And that number we would think would be small, especially after reading Miranda. But let's remember the Central Park Five. Former President Trump tried to make some campaign issue out of that many, many years ago before he ran for president, and getting New York to adopt the death penalty. The police extracted confessions for rape from 5 African-American youths, and it turned out that they didn't do it, and yet they went to jail for it. And so false confessions happen, whether it's a rash or an epidemic or not. I don't believe it's an epidemic, but I believe it happens enough. So the corroboration of the confession itself by external evidence becomes very, very important. Now, false confession theory comes in 2 ways. Psychiatrists hold sway when you're actually talking about a diagnosis of the defendant. Psychiatrists and psychologists, in my opinion, and this is just my opinion, it doesn't matter if you're testifying to a jury only about the conditions that might lead someone to falsely confess. And so that's sort of the cut line for me on the 2.
Do you think there's any relevance to the fact that information is termed personal versus professional?
Personal versus professional. Personal identifying information to me is information that is either privileged or protected by some statute or law. So those are 2, unless I'm misunderstanding the question, those are 2 different things.
So during a deposition, the opposing attorney often badgers, harasses, and intimidates the psychologist. What can be done to tone down the hostile atmosphere? And are there any laws or rules to limit such attitude or attorney behavior?
Yeah, well, first of all, you can leave. You can leave the interview. You can say and this is true with any witness. You can leave the interview. That shouldn't be the first thing you do. You should first inform the individual, look, this has gone over the line and the like. But within the rules of ethics, and this is for all attorneys, including personal injury attorneys and will and probate attorneys and patent attorneys. So it's not just for prosecutors or just in the criminal law matter. One of the rules of ethics is fairness to witnesses. And it got so bad in Florida, they actually created a rule about not badgering expert witnesses. And other states, and that was a rule that came about right before COVID. But that rule is subsumed, or is really thought to be a part of the greater rule of fairness and treatment of witnesses. And so you're always free to report that to the court. You're free to put it on the deposition, and you certainly should tell your own attorney this is occurring. But you and every other person who comes into contact with an attorney can always make a complaint in the state bar. Like, for example, the website on the New Mexico State Bar, it has a make a complaint about an attorney section, or how to file a complaint about an attorney's conduct. Every state bar has one of those.
Going back to one of the previous questions that we went over, this person's asking if you can clarify, do you put more weight on a diagnosis made by a psychiatrist versus one made by a psychologist?
Personally, no, I don't. As long as they are qualified to make the diagnosis they've made, I don't. But I'm not someone who liked the battle. I've never approved of the battle of the X. I shouldn't say never. When I was a prosecutor, I might have tried to play that game. But as a judge and being mentored by judges when I was a prosecutor, I learned that that game is not a good thing to do. And so I think it really has to do with basically the purpose by which the diagnosis was made and the credentials of the individual who made them and their experience.
Okay, and how would you approach a prosecutor attempting to provide an expert witness with answers to questions they intend to ask during direct examination, even after the witness has talked about this issue directly with the attorney?
So with the exception of the elected district attorney, every assistant district attorney has a boss. And you can simply, I would say, have a discussion with that assistant district attorney supervisor. And usually, new district attorneys have a lot of zeal, and usually talking to their supervisor will shut that down. It should, unless the elected or appointed district attorney has that as his or her mantra.
All right, it looks like we've gone through all of the questions.
Excellent.
So much for your time today. This
Well,
is fantastic.
Thank you. And I appreciate it. It was a real privilege to be here. And I know the slides are available, but if any other questions come up, please don't hesitate to reach out to me.
All right, well, it's okay if we direct people over to you.
Absolutely. Yeah.
All right. Fantastic. Thank you so much, everyone. We're going to be on for just another couple of minutes. Make sure you grab your CE link, and we'll see you next week, Professor.
And I'll depart now. Thank you.
All right. Bye-bye.